Okay, good morning, everybody, and a very warm welcome to our third Employment Club session of 2021. Those who attend these regularly know that it's a quarterly event, and we're currently sort of holding these as online webinars, and the next one's going to be towards the end of November this year. Today's session is going to be an hour long, and we've built in a little bit of time for a Q&A. Some Q&A after each session, and thank you to those who have submitted a question in advance, and we'll try and get to as many of those as we can. This session is being recorded, and we'll distribute the recording with a copy of the slides after the event, but just to reassure you that no attendee information will be shared as part of that. Everyone's microphones will be muted throughout the event, but if you want to raise a question, you can do so using the Q&A feature, which should be visible at the top of your right-hand panel on the screen. To expand this, you simply click on the right-hand arrow and submit your questions to our speakers. Questions can be submitted throughout the webinar and they'll be anonymised. If your Q&A panel isn't visible for some reason, then click the panel options button in the bottom right-hand corner, which has 3 white dots. Q&A will then be an option at the top, and you just click once to re-enable that. We will be running a few polls throughout the session, which will be visible again on the right-hand panel. Once the poll's launched, we'll let you know, and you'll have a 30-second window in which to respond, and we'll then sort of share the results on an anonymised basis and have a quick chat about those. So that's the sort of housekeeping out the way. Just to introduce myself, my name's Ed Duffield. I'm a managing associate in the employment team here, and I'm going to be talking about some of the main issues that are being faced by employers as we see the UK workforce slowly return to some level of normality and return to the workplace following the lifting of COVID restrictions. I'll then hand over to my colleague, Karen Plumley-Jones, who will take you through a couple of recent cases and look forward to up and coming developments over the next 12 months and beyond. So to kick off, I wanted just to run our first poll, just to sort of gauge what sort of issues that you as employers are dealing with at the moment, particularly relating to a return to the workplace. So flexible working requests, unvaccinated employees, managing a hybrid workforce, employees reluctant to return to the workplace, or are you dealing with all of the above or none of the above? So we'll open that poll now. If you could sort of vote A, B, C, D, E, or F, according to what's on the screen, and we'll just open that for a brief window for you to vote and respond to that. Okay, so probably the two sort of most popular answers are managing a hybrid workforce and all of the above. So it's a sort of fair mix. I mean, you know, just in terms of the type of queries that we are seeing as an employment team, that sort of mirrored what we're seeing is a lot of these particular issues, and obviously a hybrid workforce is clearly a significant issue because we're dealing with people who have been working from home for quite some time, and often want those arrangements to continue. So it's interesting that's reflected here. So moving on to look at some of these issues in more detail, and the first one are employees who refuse to be vaccinated. As I'm sure you're all aware, there's no requirement for employees to be vaccinated unless you're sort of working in the NHS or the care sector and frontline services. But other employers are dealing with individuals who may, for whatever reason, refuse to have a vaccine, and that generates issues particularly with employers who want to look at adopting a policy to say that to come back to work, you have to be vaccinated, but also for those who are in work and working, who have concerns about working alongside those who are unvaccinated. And I think the main issue to consider from an employment law perspective is discrimination, and in particular disability discrimination, not just in relation to those employees who aren't vaccinated, who may have medical reasons for not having the vaccine, but those in work who are disabled, who have concerns about risks about working alongside those who aren't vaccinated. And for employers, I think, you know, your main justification for adopting particular practices are going to be based on health and safety concerns. But you also need to consider how you're dealing with these sort of things and acting reasonably and fairly, because there's always the risk that employees could say, well, in dealing with these sort of issues, you're undermining trust and confidence. And I think it's important for employers to bear in mind the impact of vaccines, given that, as we know, a vaccinated person can still catch and spread COVID-19 in the same way as unvaccinated people. So you can't just automatically assume that vaccinated employees don't pose any risk to the workforce and the unvaccinated do. You need to think about the degree of risk and other measures you can put in place to manage that risk. Simply having a policy in place that employees can't come into work unless they're vaccinated does generate risks of discrimination claims, as I mentioned, and in particular disability discriminations, because it's probably more likely that people will have a medical reason for not having the vaccine. So you have to look at that reason and whether that individual who is unvaccinated does have that medical reason, and if they have a condition which amounts to a disability. But equally, you might be faced with issues from individuals who may have a religious or philosophical belief for refusing to have the vaccine based on some ideological values. I think in reality, it's probably going to be more difficult for such individuals to actually get a claim based on religion or philosophical belief off the ground. But perhaps a greater risk area is one of race discrimination, because, as we all know, vaccination take-up in the Black and Asian minority ethnic communities is lower. And there may be a risk that asking unvaccinated employees to remain at home is indirectly discriminatory on the grounds of race. I think, however, the fact that that particular group of individuals can still get the vaccination is a point in employers' favour. But you just need to be mindful of these issues, because reluctance to be vaccinated is tied up with wider cultural concerns about trust in the state and historic racism, and you need to tread carefully dealing with these sort of issues and have those things in mind when you're dealing with people who are wary about getting the vaccine and wary about returning to work. We've also seen a number of queries arise about employees who may be reluctant to return to the workplace because of fears about public transport, and similar points and issues arise in that. I think one point to flag up with that at the outset is that employees do have protection against being subject to a detriment or being dismissed if they refuse to attend work because they have a reasonable belief that they are in serious or imminent danger to their health and their safety. And that could include a risk posed to their health by using public transport. An important point to flag up in that context is that employees who have less than 2 years service can still bring a claim of unfair dismissal if they're dismissed because they believe they're in serious and imminent danger to their health and safety. They don't have to have that 2 years service to bring an unfair dismissal claim. I think if you're faced with those sort of issues, the first step you should be considering as employers is discussing it with the employee directly and try to understand the reasons for their concerns, taking a supportive approach as far as you can and looking at the different options that may be available, such as, can the employee continue to work from home for the time being or on a temporary basis? Could you look at changing their hours of work so that they don't have to use public transport during the rush hour, either coming to or coming home from work? are there any alternative options for them to get to work? Could they drive, for example, or could there be, the possibility of a car share with another individual who's coming to the same place of work? Could they walk or cycle to work? And I appreciate not in every case that's going to be possible. Then employees won't have access to a car, or they'll live on a bus route or a train route, and that's really the only option. But it's important to not just dismiss that out of hand, and really consider it carefully with the employee and consider their own personal circumstances. In terms of the risk, much is going to depend on those circumstances. But if, for example, you've got an employee who suffers from anxiety and has a fear of using public transport because of that, then the level of risk in dealing with that employee in terms of treating it as a disciplinary issue or potential dismissal is going to be higher than someone who doesn't have an underlying health condition. But it's important to look at those on an individual basis and consider the circumstances. Another issue we're seeing a number of queries on is in relation to working with unvaccinated colleagues. And I mentioned before, some people will be reluctant to get the vaccine but want to come back to work, but that generates concerns by those who are vaccinated, and they'll say, well, I don't really want to work alongside those who haven't had the vaccine. Again, it's important to understand what the employee is concerned about. Are they worried about catching COVID themselves, or are they worried about passing it on to a vulnerable relative at home? Do they suspect the unvaccinated colleague has COVID, or is there something else going on here? Is there a personality or other work-related issue between the two employees that's causing or driving this concern? It's important to try and work with the employee to resolve their concerns, which may involve reassuring them about the safety measures you have in place in the workplace, and look at what additional safety measures you can put in place, such as maintaining social distances, putting up screens, practicing good hygiene, and that sort of thing, and reminding the workforce that they need to adopt to those safety measures that you've put in place. Obviously also explaining that vaccinated people can still pass on the virus as well. That could be part of your messaging and conversation about that. If the employee's concern about working with unvaccinated people is genuine and can't be resolved, and there may be an underlying health condition here, can they work from home on a short-term or longer-term basis? Or could they potentially work at a different part of the office or workplace so that they don't come into contact with the individual who's unvaccinated? If the concern isn't genuine, or there's no underlying health conditions and they're just simply refusing to come to work alongside unvaccinated colleagues, then you could potentially consider taking disciplinary action for failing to follow a reasonable management instruction. But care needs to be taken in dealing with those sort of issues. Work with the employee, try to understand what their concerns are, and in particular whether there are any other underlying health issues. As we're seeing more employers require employees to come back to work, and obviously for a long time employees have been working from home, and in a lot of cases employees will have been working from home successfully and productively and efficiently. We are seeing an increase in flexible working requests because employees are seeing, well, actually, I quite like working from home either all of the time or some of the time. It works better for my work-life balance and my family commitments, and therefore I'd like to carry on doing that. So we're seeing a lot more requests from employees to work flexibly, and how should employers handle these in light of wanting to try and promote a return to the office? Just by way of a quick recap, any employee who has 26 weeks continuous service can make a flexible working request up to once a year, and that request is to permanently change their terms and conditions of employment, and that can relate to their hours of work, the times of work, or their place of work. Employers can reject their request, but they have to do so on one or more of the 8 specified business reasons, which include additional cost, detrimental impact on performance or on quality, an inability to reorganize work amongst existing staff. So there are 8 specified reasons you can rely on. Your obligation as employer is to consider the request reasonably. You should discuss it with the employee and see how the changes would work in practice. Try and look at the advantages and disadvantages and considering any alternatives to the request if you can't accommodate it fully. Now, of course, it's probably in practice going to be more difficult to reject a request where an employee has been working from home during the pandemic and has been doing so successfully, productively, and there aren't any concerns. But equally, employers are still entitled to and indeed expected to consider the request and your requirements. And it doesn't automatically follow that simply because working from home arrangements have applied and worked up to date, none of the statutory reasons for rejecting a request would apply. For example, an employer could say that working from home arrangements worked well because everyone was doing it. We had no choice. Everyone had to work from home. We had to adapt, and obviously it worked well in those circumstances. But we're now in a different place. People are starting to return to the workplace and return to the office, and there is a greater requirement now for the majority of staff to return. For example, because of more effective team working, mentoring, supervision, and to maintain good levels of performance. So, the circumstances have changed, and that could be something that employers rely on as a reason for rejecting that request. But the key takeaway on this is that it's important to fully and carefully consider all flexible working requests on an individual basis and not adopt a blanket policy. No, you can't work from home or you can't work flexibly. You need to look at each request individually and consider the reasons why you can't accommodate it if you are going to reject it. And importantly, consider any alternative arrangements that you might have. And the potential risk of just simply rejecting a request has been illustrated quite recently by an employment tribunal case, which involved a new mother who had her request refused, and that individual was awarded nearly £185,000 in compensation. Now, in that case, the employer refused to consider the request to work 4 days a week and to finish at 4 p.m. to pick up her new child from nursery. Now, the employer here didn't seriously consider the request or propose any alternative working arrangements, and the tribunal found that they had subjected the employee to indirect sex discrimination, and because statistically it's accepted that the majority of people with childcare responsibilities are women, and in this case their policy of requiring full-time working and not allowing an earlier finish was indirectly discriminatory against that individual on the grounds of sex. Now, the employee, who was a sales manager for an estate agency, was highly paid. She was earning over a six-figure salary, which partly explains the level of compensation that she was awarded. But even so, it demonstrates the need for employers to treat flexible working requests seriously, fully discuss it with the employee, consider alternatives, which could include, for example, the trial period, rather than just rejecting the request outright. Could we have the next slide, please? So the next issue I wanted to talk about was employees who want to work from home outside the UK. And we have seen this from time to time. Employees, well, they've been working from home successfully. Well, why can't I work from home in the south of France? I'm still going to be doing exactly the same work and contactable and doing it online. Why not? Well, there are a number of issues that can arise from those arrangements. The largest one principally are tax, social security and corporate status. In particular, what tax regime is going to apply to the employee who are working abroad, where a social security contribution is going to be paid. Does the fact that the employee is working abroad mean that the employer accidentally ends up with a base in that country, bringing them in that country's corporate tax regime? There are also likely to be immigration issues. Does the employee have the right to work in the host country? Particularly important now as following Brexit. So it's very important to take advice on before agreeing to those working abroad arrangements. Other issues that could arise are jurisdictional. Now, if the employee is working for the UK company, albeit based abroad, and the employer doesn't have a base in that country, then it's likely that the employee is going to retain that sufficiently close connection to the UK to retain UK employment rights. But you can't rule out the fact that they might attain local employment rights, and they might be more favourable than the employment rights here in the UK, particularly in some of the EU countries. They have more generous employment protection. So those sort of issues would potentially arise as well. There are, of course, also practical issues. How is the employee going to be supervised? Can you insist on them attending the UK office from time to time? And if you can, who pays their travel costs? There are also other legal issues such as data protection, insurance, health and safety, regulatory requirements. So it's important to bear all those issues in mind rather than sort of simply agree to that because the employee's asking for it, and it may be convenient. As we identified in the poll at the outset, managing a remote or hybrid workforce is a key issue that you're grappling with at the moment. And we are seeing more employers looking at hybrid working arrangements because employees want to continue with having the flexibility of working remotely. So employers are saying, well, okay, we'll allow you to work remotely, but for part of the time. So part of the time you work from home and the remaining time you're in the office. But you need to consider carefully those sort of arrangements, and in particular there are a number of issues that arise, and specifically work opportunities, both in terms of promotion and recognition at work, because we can foresee circumstances arising where those who are at work potentially get better opportunities because they're more visible to management. And that could impact on promotion chances and also the payment of discretionary bonuses. That could potentially lead to discrimination issues, and in particular sex discrimination issues, if a greater number of female employees work from home on a hybrid basis than male colleagues. One way to try and head off those sort of issues is look at your diversity monitoring data and refresh that to include data on remote office working status, because that could help identify any potential discrimination risks. And it may be necessary if you're in the public sector and subject to the public sector equality duty. There are also, of course, practical issues with supervision and productivity, and those sort of things need to be considered when adopting hybrid working practices. And as part of that, you could consider introducing a hybrid working policy. Now, I'm an advocate for saying you don't have to have a policy for everything, but sometimes having a policy in place can be helpful. And this could be a circumstance where it is, because if you are changing working arrangements for employee, in particular their place of work, even if part of the time they're still office based and part of the time they're home based, then strictly speaking that would amount to a change that is notifiable under the Employment Rights Act as a change to their terms and conditions of employment. Now, of course, that's going to be easy for new employees and new starters, but for an existing workforce, employers would potentially have to notify them of that change of place and work. And that's going to be more challenging, particularly if you've got large numbers of employees. One potential solution here is to send each employee a statement making it clear that they're a hybrid remote worker, and it should be drafted in such a way that it would amount to a change of notice under the statutory requirements. However, that might be, again, more challenging, particularly if you've got a large number of employees. An alternative is to adopt that hybrid working policy on a discretionary non-contractual basis, which would involve introducing hybrid working policy and setting your expectations around home working, asking line managers to agree informal working arrangements with individual employees. The point to flag up with that, however, is that changing those arrangements in the future, particularly if they've been in operation for some time, could risk breaching trust and confidence and could generate discrimination risk as well, particularly if childcare arrangements have been made to fit in with those hybrid working arrangements. So those are issues to think about when you're looking at hybrid working and introducing that. The last issue I wanted to talk about was reducing pay for employees who wish to work from home permanently. And before I get onto that, there was another poll that we were going to do, which is whether you think employees should be paid less if they wish to work from home all the time. So it's a simple yes or no. Do you think employees should be paid less if they wish to work from home all the time? So I'll give you a few seconds just to vote either yes or no on that one. So the vast majority there think that no, employees shouldn't be paid less if they work from home all the time, which was contrary to what an unnamed cabinet minister said recently, who said he thought it was unfair for those returning to the office not to be paid more on the basis that people who've been working from home haven't been paying their commuting costs. So in effect, they've had a pay rise. That didn't gain much traction to the business secretary, however, who rejected the idea that civil servants should be paid less if they continue working from home. But it could be an issue over time. It could be particularly the case for those in the public sector where employers will have responsibility in relation to managing public money and feel that they can't justify, say, an inner London allowance for employees who are no longer commuting and who are living in a different place. Of course, if you are changing any salary, that would need to be done through agreement, and potentially it would affect a large number of employees, which, if you're going to then push that through by way of a termination in re-engagement, would then possibly trigger the obligation to undertake a collective consultation exercise, and that would involve consultation with recognised trade unions as well. I think a number of issues to consider as part of that is why employers pay allowances or higher pay for those working in different locations in the first place. If the original justification for introducing them was not based on commuting costs, then it's going to be more difficult to remove them simply because employees don't have those costs going forward. Employees will, of course, be able to argue that the work they're doing is of the same value, and the rates aren't usually set by whether the employee actually lives somewhere more expensive. So it might be hard to justify reductions based on an employee moving to somewhere where there's a lower cost of living or where they don't have those commuting costs. If you are looking at this, then additional costs of working from home would need to be taken into account, such as electricity, heating, broadband costs, etc. And any allowance based on commuting might need to be replaced with a smaller allowance for those costs rather than removed completely. There could also be equal pay issues, and employers will need to be sort of confident in having a non-discriminatory material factor defence for changing that pay. So those are the main issues that I wanted to talk about. I'll now just spend a few minutes picking up on a few of the questions that have come in and that have been submitted in advance. The first one to pick up was whether we can make redundancies before the furlough scheme closes. And as I'm sure you're all aware, the furlough scheme comes to an end at the end of this month. It's unlikely it's going to be extended. And as to whether you can make redundancies before then, I mean, yes, you can, but what you won't be able to do is claim furlough, the furlough grant in relation to any period where the employee is under notice. The notice has to be paid by you as employer, but you would be able to make redundancies in the normal way. The next question I was going to pick up was whether you could require employees to attend a work event. And this is largely going to come down to whether it's a reasonable management instruction to do so, and the nature of the event and the terms of the employment. But that aside, the key considerations to take into account are the ones that I discussed earlier, and in particular whether employees who don't want to attend a work event have any underlying health conditions, and that's the reason why they're reluctant to attend. consider what steps you can be taken to minimize the levels of risk at the event. But obviously, if it's a social event or a networking event where there's going to be high levels of contact and it's more difficult to maintain social distancing, then in those sort of circumstances, it's going to be more difficult to justify requiring those employees with genuine health concerns to attend. Another question that came in was, can we ask for data on employees' vaccination status? And this gives rise to a number of issues, principally in relation to data protection. And I think it's unlikely that you'd be able to compel an employee to disclose whether they've had the vaccine, unless you're in a particular sector where vaccination is compulsory. So that would be you'd need to request that on a voluntary basis and as part of your risk management approach. From a data protection perspective, you need to have a legitimate interest to show the reason why you're requesting this information and show that processing is necessary to achieve that legitimate interest. So those are important considerations to bear in mind there. Another question that's come in is, what should we do if an employee is reluctant to return to the workplace because they live with someone who is clinically extremely vulnerable? Now, on this, the updated guidance for clinically extremely vulnerable people, which was issued in July, indicates that they should follow the same guidance as others, but also consider what other precautions they should take to minimize the risk of catching COVID-19. The main risk here from an employment law perspective is disability discrimination, as it's still unlawful to treat an employee less favorably because of an association with a disabled person, even if the employee themselves is not disabled. So your employee may not be disabled at all, but if they are living with somebody who is clinically extremely vulnerable, it is perhaps highly likely that that person themselves is going to be disabled. So you need to tread carefully with these individuals and ensure that you're considering their request to remain at home carefully, and you're not treating them less favorably because of their association with that disabled person. So consider the reasons for their concerns, whether they can continue to work from home, or if any alternative arrangements can be made, what measures can put in place to allow them to return to work to minimize the risk of them being exposed, such as regular testing of staff, maintaining social distances, mask wearing, and things like that. Those are the sort of things that you are going to have to consider. If the employee's employed in a role that cannot be done from home, could they be redeployed into another role that allows them to work from home? It may not be possible, but those are the sort of things that you would need to think about. I'm conscious of time. There's a final question I just wanted to pick up that did come in. Is what can we do if a teacher who has no medical conditions is anxious about contracting COVID-19 in the workplace and is asked to work from home? I think in this sort of situation, it's important to understand the reasons for the anxiety about this and consider what, if any, measures can be put in place to minimize the risk. Now, on the face of it, it's perhaps unlikely that a teacher would be able to work from home on a full-time basis. But if they have been delivering online lessons remotely and successfully during lockdown, consider whether that could be extended. I think it's important here to consider the nature and extent of the anxiety, because anxiety could be a disability. Now, employment tribunals they focus more on the effects of the condition rather than the label that's attached to it. So you can't simply say that all conditions of anxiety are going to be disabilities, but if it is substantial and serious and has lasted or is expected to last 12 months or more, then it's likely to be a disability. So the duty to make reasonable adjustments would kick in. So consider in that sort of situation, maybe getting some medical advice, perhaps from occupational health, and looking at the alternatives. So that's all I wanted to cover for now. I hope that's been helpful. I'll now hand over to Karen, who will take you through the update on cases and what's coming up in the future. Thanks very much.
Thanks, Ed, and good morning, everyone. So, as Ed mentioned, I'm going to have a look at a couple of recent important cases first. One of those deals with unfair dismissal, and the other is on religious and belief discrimination. So, the first case I want to have a look at is L and K, which is a Scottish case, and the decision was in the Court of Session. I'll give you a little bit of background, first of all. So you may be aware there are 5 potentially fair reasons for dismissal, and they are capability, conduct, redundancy, breach of a statutory duty or restriction, and some other substantial reason of a kind such as to justify the dismissal of an employee holding the position which the employee held. And this last reason is usually referred to as dismissal for some other substantial reason. So what were the facts in this case? Well, the claimant was a teacher, and he was charged with possession of indecent images of children that were found on a computer at his home. However, the charges were later dropped and he wasn't prosecuted. His son lived with him and also had access to the computer, so it was possible that he could have downloaded the images. The son also was charged but wasn't prosecuted. The teacher had 20 years unblemished service. He told his employer about the charges against him and was called to a disciplinary hearing to discuss them. Now, after that hearing, the employer decided that there wasn't enough evidence to conclude that the teacher had downloaded the images, but there was a risk that he was responsible. And in their view, that presented an unacceptable risk to the children. There was also a serious reputational risk to the employer if his employment continued. So the school decided to dismiss him, and he claimed unfair dismissal. So we're going to do a quick poll on this case. It's an easy question. Do you think the dismissal was fair or unfair? So let's roll that now. So vote now. Okay, so it's a fairly even split between the two. 39% of you who responded think it was a fair dismissal, and slightly more, 47%, think it was an unfair dismissal. Now, interestingly, when it got to the Court of Session, they held that it was a fair dismissal. The reason for the dismissal was some other substantial reason justifying the dismissal. It wasn't misconduct. So the school didn't need a reasonable belief that the teacher had downloaded the images. The school had concluded that it couldn't maintain trust and confidence in the teacher, and they had to protect children, so they couldn't take any risks. And the court found that the school had acted reasonably in treating that reason as a sufficient reason for dismissal. So that's all well and good, but what does it mean for employers? Well, I think it's a really helpful case if you work for an organisation where the safety of children or vulnerable adults is critical. So that's obviously going to cover other schools, but it will cover organisations like care homes and hospitals as well. But I think there are a number of lessons we can learn from this case that are relevant to all employers, such as the importance of setting out very clearly the issues that the employer is concerned about in the letter inviting the employee to a disciplinary hearing. And it's also really important to identify the correct legal reason for dismissal. So I'm going to move on to the second case now, and the issue before the Employment Appeal Tribunal in this one is a belief that there are only 2 biological sexes, a philosophical belief which is therefore capable of being protected under the Equality Act. So a little bit of background first. Religion or belief is a protected characteristic under the Equality Act, and belief is defined as any religious or philosophical belief and a reference to belief includes a reference to a lack of belief. So there have been a number of cases where the employment tribunals have had to decide whether a particular belief qualifies for protection or not. And this case is the latest in a long series of cases on that issue. Ms. Forstatter was a visiting fellow at a think tank. She believes that a person's sex is a material reality that shouldn't be conflated with gender or gender identity. She also believes that being female is a biological fact and that a trans woman is not in reality a woman. She believes that a person can identify as another sex and can ask people to go along with that and can change their legal sex, but that doesn't change their actual sex. And she engaged in debates on social media about gender identity issues, during which she made some remarks that trans people found offensive. But her colleagues also found out about these debates, and they found her comments offensive as well. So it came to the attention of her employer, who carried out an investigation, and after that her post wasn't renewed. She brought a claim and alleged that her beliefs constituted a philosophical belief, and that the fact that her employer hadn't renewed her contract was discrimination on the grounds of her belief. The Employment Appeal Tribunal held that gender-critical beliefs, including the beliefs that the employee held, are protected under the Equality Act. They said that a philosophical belief will only be excluded from protection if its expression would be akin to Nazism, totalitarianism, or would amount to inciting violence or hatred, and would thereby likely to be excluded from the protection of rights under the European Convention on Human Rights. Ms. Forstatter's gender-critical beliefs, which were widely shared and didn't seek to destroy the rights of trans people, clearly didn't fall into that category. And the EAT went on to say that beliefs that are offensive or shocking or even disturbing to others can still be protected. That's not the end of the story, though. The case will now go back to the tribunal for it to decide whether her contract wasn't renewed because of her beliefs. So was she actually discriminated against or not? What does this decision mean for employers? What are the implications? Well, it is a major decision, not just because of its impact on the debate over trans rights and the rights of people who hold gender-critical views, but also because it has a wider impact on the definition of philosophical belief. And the judgment clarifies that all except the most extreme beliefs are now capable of being protected by the Equality Act. On the positive side, it should mean that less tribunal time is taken up in future with deciding whether a belief is protected or not, and that should allow tribunals to focus on whether discrimination has actually taken place. But the impact of this judgment will go much wider than employment claims, and it will affect service providers, landlords, educational bodies, trade unions, and any other association or organisation that is subject to the Equality Act. So that's a major decision. I'd like to move on now to have a look at what's coming up in the pipeline, and I've put on the slide what we can expect during the rest of this year. I'm going to pick out the most important ones of those to talk about. The first one being the end of the furlough scheme on the 30th of September, which Ed has already mentioned. So there are still 1.5 million employees on furlough, and if they include some of your employees, no doubt you're starting to think about what you're going to do with them when the scheme closes. HMRC has updated its guidance on the furlough scheme, and they've said that you need to bring employees back to work on their agreed terms and conditions, or agree changes to them, or consider ending their employment, which will presumably be by reason of redundancy. By the 5th of October this year, you need to carry out gender pay gap reporting if that applies to you. The normal deadlines fell earlier in the year, so they were the 30th of March for employers in the public sector and the 4th of April for private sector employers. But the Equality and Human Rights Commission announced that they won't take any enforcement action until the 5th of October this year. So employers have effectively had an extension. The Commission has published guidance on how to calculate the gender pay gap where you have had employees on furlough. So have a look at that if that applies. And I read just this morning that only 50% of employers who need to carry out their reporting have actually done it so far. So that may be a reminder that you've only got a couple of weeks or so left to do that. I want to touch briefly on compulsory COVID vaccinations for care home staff. And now that comes into law on the 11th of November. Registered people have to ensure that any non-resident over 18 doesn't enter the premises unless they've provided evidence that they have been fully vaccinated or that they can't be vaccinated for clinical reasons. There are some exemptions, which includes residents, friends and relatives, and anyone who enters the premises to provide urgent assistance or maintenance. The Department of Health and Social Care has issued some guidance on this, and that states that employers need to keep records of vaccination or exemption status. They need to consider implementing a vaccination policy, and they should consider deploying an employee to an alternative role if they're not vaccinated. If that's not possible, then the guidance goes on to state that the employer may have a fair reason for dismissal, which would either be contravening a statutory restriction or some other substantial reason justifying dismissal. We're still awaiting for guidance on the medical exemption, but a temporary self-certification process was introduced just yesterday, and that's going to remain in place for 12 weeks. And there has been a judicial review application filed a week or so ago into the whole requirement for care home staff to be vaccinated, and that alleges that the requirement for vaccinations is unlawful. So we'll have to see what happens in relation to that. You may have seen that there was a further consultation issued last week on requiring frontline health and social care staff in England to have COVID-19 vaccinations, and the consultation also goes on to ask about whether they should have compulsory flu jabs as well. And again, medical exemptions would apply to that. Consultation closes on the 22nd of October, so you might want to have a look at that if it's relevant to you. So moving on to what's coming up, looking at next year and onwards. So picking out a few of the most important developments that we're expecting. First of all, 5th of April next year, the concession on right to work checks comes to an end. At the moment, you can ask a new recruit to send you scans or photos of their ID documents and then set up a video call to see them with their original documents. But from the 6th of April next year, you'll have to go back to face-to-face and physical document checks. I suppose there's a possibility that may be extended further, that the concession might become permanent if we see a large proportion of the workforce working at home for all or part of the time, but I haven't heard anything official about that yet. I also want to have a look at the duty to prevent sexual harassment. So you may remember there was a consultation on sexual harassment in the workplace, and the government has recently responded to the consultation. They announced that they're going to introduce a new duty on employers to take all reasonable steps to prevent sexual harassment at work, and they'll also introduce explicit protection from third-party harassment. And on top of that, the government is considering extending the time limit for discrimination claims from 3 months to 6 months. And the reason for that is that it was felt that particularly in relation to discrimination claims that arise during pregnancy or maternity leave, it's a very difficult time for somebody to get a claim in promptly within that 3-month time limit. So it's only fair to extend that to 6 months, but they've decided to extend it for everyone bringing a discrimination claim, not just a pregnancy discrimination claim. I haven't seen any further details about the sort of shape that this new duty is going to take, and no timescales have been given yet. Obviously, the pandemic is taking up a lot of parliamentary time at the moment, so quite a few of the employment developments that we're expecting to happen are being postponed. So we've had some questions in around the developments that are coming up in the future, and I'll answer a couple of those now. One of the questions is around the concession on right to work checks. So the question is, when that concession comes to an end, will we have to carry out physical document checks on employees who started work during the pandemic? And I think that's a really good question, but we have got guidance on that, which says that employers won't have to carry out retrospective checks where they've used the concession, which is really helpful. You won't have to go back and check documents for every new joiner who started during the pandemic. But as I mentioned earlier, you will have to start physical document checks again from the 6th of April next year. Another question that's come in is a really good one. So someone's asked what's happened to the employment bill and the proposal to extend maternity rights. The employment bill was promised to us a couple of years ago. I think it was mentioned in the Queen's speech back in 2019, and it's due to cover a number of different topics. So it will look at strengthening the rights of gig economy workers. It's going to make flexible working the default, and it will also extend redundancy protection to 6 months after a woman returns to work after maternity leave. And that protection would also be extended to people taking adoption leave and shared parental leave. We were all hopeful that it was going to be included in the Queen's speech this year, but there was no mention of it at all. And this is one of the proposals that has been delayed by the pandemic. We have been told that it will be brought forward when parliamentary time allows, and I'm looking out for this. So watch this space, and we'll let people know once that comes about. But I know a lot of employers were interested in the proposals to extend maternity rights. It's an important area. So that brings me to the end of what I wanted to tell you about this morning. I'd like to finish by thanking everybody for joining us. If you've got any follow-up questions on the areas that we've covered this morning, or if you've got any other employment law related issues, then please do contact a member of the team.
Karen,
yes.
I think apologies for interrupting. I think we've had some sort of further questions come in during the session, and because we've got a little 5 minutes or so before we finish, so I'm happy to sort of pick up some of those.
Yep, that's a really good idea.
Before we wrap things up, just to
sure.
pick up on some of the questions that come in. So one of them is saying, I agree, no reduction in salary. This is in relation to employees working from home and whether we can justify reducing their pay because they're working from home. They say, I agree, no reduction in salary. However, what about London waiting for someone who no longer commutes to London, which is a fair point. I mean, ultimately that is likely to be a contractual entitlement of the employee in question. So you would have to negotiate and try and agree to remove London waiting, but it's important, as I mentioned earlier, to consider the reasons why that's been implemented in the first place. Is it to cover additional commuting costs, or is it to cover the additional costs of living in London? Often it's a combination of the two, but it's important to consider the reasons why that London waiting has been applied in the first place. But ultimately, it's going to be a negotiation and hopefully agreement with the individual or individuals, rather than just simply removing that, which would place you at risk of being in breach of contract. Another question that has come in is an interesting one. someone who works in retail, and currently we're asking staff to continue wearing masks at the moment. However, we're hoping to have a Christmas party, but I'm not sure if we can do this unless everyone wore masks there as well. If employees don't want to wear masks, are we being contradictory? It's an interesting one. I think if you're in retail and you're asking staff to wear masks, presumably it's because they are working in the store, in the retail units, and obviously they're in customer facing roles or a lot of the time, or will be in close contact with others. So I think you can probably differentiate between your practices at work and also at the social event. I think maybe a way to approach it is to ask staff what they think about it. Would they want to wear masks or feel more comfortable coming to a social event if they were wearing masks or not? And canvass opinion on it. I don't think there's a right or wrong answer to it, but I think you can justify the difference because they're obviously in an environment where they're in customer facing roles or coming into contact with members of the public, and it's part of your wanting to ensure that you're maintaining that sort of responsible presence as a retailer. Another question that's come in is an employee doesn't want to be vaccinated as he's trying to start a family and worried about the effects of the vaccine. He can and has been working from home but wants to come into the office. We've said he can't until he's double vaccinated. Is this okay? There's no discrimination issues. I think again, you've got to sort of look carefully at it and the reasons why he's got that concern about the vaccine, and whether, and also the reasons why you are reluctant to allow him to come into the office unless he's double vaccinated. What are the concerns here? Are there any other measures that can be put in place? Have you got other employees who have been raising concerns about that individual coming to work who who hasn't been vaccinated, and can measures be put in place? Just looking at some of the questions. One was, can you legitimately ask employees to show proof of vaccination? I mean, I think I mentioned that in the talk. I think it's going to be difficult to do that unless you're in a sector where as Karen mentioned in the care sector about compulsory vaccination. So I think you'd have to consider looking at doing that on a voluntary basis, but explaining the reasons why you're asking for that as part of your risk management approach. So I think that's probably all we've got time for now, unless you want, if there's anything else that's come in, Karen, you wanted to pick up?
No, I don't think so, Ed. Thanks for that. So to wrap up then, when you exit the webinar, you'll see a short feedback questionnaire. If you could take a few seconds to complete that, it would be really helpful to us. We do read all of the feedback, all of the comments that come in at the end of our webinars, and try and build in suggestions for our future events. Mentioning future events, we have a couple of things coming up that you might be interested in. So first of all, we've got a special webinar next week to celebrate Business Women's Day, and you may want to attend that. The keynote speaker is Fran Halsall, who's a triple Olympian, and I'm sure she'll have a lot of really interesting things to say. There are more details about that one on the events page of our website, so do go and have a look at that. And finally, our next employment club takes place on the 23rd of November at 10 o'clock, and we'll send you an invitation by email nearer the time, so do look out for that. As Ed mentioned, we'll be sending out a recording of this webinar and the slides in the next few days. Once again, thank you very much for attending. Enjoy the rest of your day, and goodbye.